On May 17, 2011, respondent sent an email to the ADAs in her office as well as to the office secretarial staff stating that she had made a Facebook page that is fake for us to befriend people and snoop. Her name is Brittany Bella. Use it freely to masquerade around Facebook. Please edit it to keep it looking legit. Use it to befriend defendants or witnesses if you want to snoop. All right, everyone. Good morning. I'm Leonard French, your favorite copyright attorney. And for our next story this week, I have a really interesting case out of the Supreme Court of Pennsylvania, the Disciplinary Board of the Supreme Court of Pennsylvania. This is the Office of Disciplinary Counsel versus Stacey Parks Miller, an attorney in Center County, Pennsylvania. Petitioner, Disciplinary Counsel, files this petition and charges respondent, Stacey Parks Miller, with professional misconduct in violation of the rules of professional misconduct as follows. Respondent is an attorney, born 1969, admitted 1994 to practice law, has a registered public office in Center County, Pennsylvania, and is subject to disciplinary jurisdiction of the Disciplinary Board of the Supreme Court of Pennsylvania. She is, or was, the district attorney of Center County. So, just in case anyone's unaware, the district attorney is the main prosecuting entity of an entire county. So all of the charges go through the district attorney. Charge 1, the ex parte matters. Now, there's a couple of these, so bear with me. When we get through a couple of these matters, you'll see what we're getting to. This is building to something. The Cluck matter. February of 2013, respondent sent an email to the Honorable Judge Bradley Lunsford, his secretary, his law clerk, and defense counsel relating to a criminal prosecution. The subject of the email was Justin Cluck. The email stated, "We would ask that you strike the portion of the order that sets bail in this matter. The Commonwealth was never heard on that issue and wishes to be heard. While it was set for the last time, we never addressed it. This issue was never litigated before the court, and the court cannot set bail without hearing from us," etc., etc. On the same day, in response to her email, Judge Lunsford replied to respondent stating, "Good point. Probably should have brought him back here first. We'll schedule that one in." In response to his email, respondent replied, ex parte, without copying defense counsel, to Judge Lunsford. In the email, respondent argued that Judge Lunsford should rescind the order. Specifically, she stated, "Will you," and sick means that they're copying the "you" as she wrote it, "will you rescind the order so we can deal with it then? He is still in, he has not been let out, and your order just came through. Otherwise, we will walk out. You have no idea where he will go. You don't even have a supervised bail eval." So it sounds like she's criticizing the judge and telling him to take some kind of action, but she's not talking to the judge and the opposing party, or with the opposing party present. She's doing this without them. Respondent communicated ex parte with Judge Lunsford during Cluck and was not authorized to do so. The judge had responded, saying that he is already gone, meaning he's already been released or whatever. By communicating ex parte, she sought to influence him by legally prohibited means. By communicating with him, respondent engaged in conduct which undermines the integrity of the criminal justice system. The respondent knowingly communicated. The evidence is the drastic difference in formality in the second email in comparison to the first. The action that was requested was directed at a single individual. The "you" is Judge Lunsford. Respondent failed to correct the error at any point, and respondent failed to inform the defense counsel at any point. By failing to inform the judge that his initial communication was ex parte, respondent knowingly assisted the judge in conduct that is a violation of the rules of judicial conduct. By supplemental request for statement of respondent's position, petitioner advised respondents of its concerns arising from the ex parte communication. In June of 2015, respondent's attorney filed her verified response in which she said it is denied that respondent intended to communicate with the judge. Respondent, in connection with this disciplinary matter, knowingly or recklessly made a false statement of fact as well. So just in that first one, she's accused of communicating with the judge ex parte. The judge, I don't know if you noticed, is also accused of communicating with her ex parte. But we're not in the judge's petition, we're in Stacey's petition. Or should I say Ms. Parks Miller's petition. And she's also accused of making a false statement or a lie in responding to that accusation. The Arron matter. Patrick Arron filed a petition for writ of mandamus. I forget what mandamus is. Judge Lunsford scheduled a hearing to determine the merit of the writ of the request. The respondent sent an email. Stacey Parks Miller sent an email solely to Judge Lunsford. The subject was Arron v. DA Stacey Parks Miller. She said in her email, "Are you serious? Scheduling a hearing with me and a pro se inmate on a writ of mandatum? Sick. Making me answer to him about the complaints he filed about guards, giving him a teleconference face-to-face, making me report to him." She's obviously incensed that the judge would treat his writ of mandamus with any sort of merit and allow a hearing to be held, which is, I believe, what's supposed to happen when someone files the right court paperwork. You hold the appropriate hearing or take the appropriate procedure. But she apparently disagrees. Respondent communicated ex parte with Judge Lunsford during Arron while not authorized to do so by court or law. Respondent's email also included 2 case law citations to further convey her point, evidencing respondent's intention to influence the judge's decision. By communicating ex parte, she sought to, and in fact did, influence him. On that same day, he replied, "Okay, thanks for clearing that up. I'll cancel the hearing." Thereafter, Judge Lunsford denied the petition for writ of mandamus in Arron with prejudice, which means it can't be filed again. By communicating ex parte, respondent engaged in conduct that undermines the integrity of the legal system. By failing to inform him that his communication was ex parte, she knowingly assisted him in violating the rules. Again, she was advised that the ex parte communication had been sent, and she wrote, "Although there was no way for respondent to have emailed Mr. Arron, respondent should never have sent the email to Judge Lunsford. The email with the information provided was sent in frustration and should have been included in a proper motion that was filed and served in accordance with the Pennsylvania Rules of Criminal Procedure." So that's 2 we've got now. The Shirk matter. May of 2014, a jury trial took place before Judge Grine in Commonwealth v. Shirk in Center County. During the trial, Brian Manchester Esquire defense counsel presented testimony of a Dr. Randall Tackett, a pharmacologist, challenging evidence of Mr. Shirk's blood alcohol level. On behalf of the Commonwealth, respondent, Stacey Parks Miller, introduced Dr. Harry Camero, a pathologist, to dispute the validity of the defendant's expert. During closing, Attorney Manchester defense counsel included argument which calculated Mr. Shirk's blood alcohol content based upon the number of alcohol beverages he had allegedly consumed. Mr. Shirk was found guilty and released on bail pending sentencing. Respondent then began text messaging Judge Grine. In total, 15 text messages were sent by respondent to Judge Grine between 8:55 a.m. and 9:45 a.m. on May 14, 2014. These messages were deleted from respondent's phone at a later date. The first 30 characters of each message were recovered from respondent's phone by ODC, the Office of Disciplinary Counsel, through digital forensic analysis. Only respondent's outgoing messages were recovered. Of the 15 messages sent to respondents, 6 specifically relate to the Shirk matter. "You laughed when Camero told. You laughed. You agreed. You didn't bust out. Calculations adding and subtracting. Wondering what the poor kid's family. And as part of restitution, you should..." Respondent communicated ex parte with Judge Grine during Shirk while not authorized to do so by law or court. By communicating ex parte with Judge Grine, respondent sought to, and in fact did, influence him by legally prohibited means. By communicating ex parte, respondent engaged in conduct which undermines the integrity of the criminal justice system. A sentencing hearing was held in July in Shirk. At the hearing, additional argument was presented by both defense and the Commonwealth. The Commonwealth's argument was presented by respondent. Respondent's argument called Dr. Tackett wholly incredible and emphasized Dr. Camero's medical opinion. On July 7th, Judge Grine sentenced Mr. Shirk to a minimum of 3 years. The sentence did, in fact, include a requirement of restitution. And so they're connecting the dots there. She asked for restitution, and she got restitution. And she got restitution by asking for it, or at least in part by asking for it, ex parte and without the defense counsel's ability to know, hear, respond to that stuff. The best matter. On May 19th, a motion in limine hearing, which is an evidentiary hearing, took place at 1 p.m. before Judge Lunsford again. I'm not going to read the words because of the YouTube apocalypse box. The hearing occurred the day before the jury trial was to begin. The purpose of the hearing was to determine whether the defense would be able to pierce the law that protects victims during the trial. The hearing was held as scheduled and concluded at approximately 1:24 p.m. During the hearing, Assistant District Attorney stated, "So not only does the DNA then match the swab from Mr. Best, but also the swab has indicia of her presence as well." Respondent sent 2 text messages to Judge Lunsford then between 1:26 and 1:27, just 3 minutes later. These messages were deleted. The first 30 characters were recovered. The 1:27 message begins, "A swab, oh, he said indicia." The text message copies the Assistant District Attorney but does not include opposing counsel. It is believed and therefore averred that in her group text message, Respondent was referring to ADA Boob's statement during the hearing. Respondent communicated ex parte with Judge Lunsford during best. While not authorized to do so, it did influence him. By communicating, it undermines the integrity of the criminal justice system. On the same date, Judge Lunsford entered an order at 4:16 granting the Commonwealth's motion precluding attempts to pierce the shield in place for the victim. By request for statement of respondent's position, stated January 21st, 2015, petition advised respondents of its concerns arising from the text messages. Petitioner also made a request for the production of all text messages sent between you and Judge Lunsford prior to the Office of Disciplinary Counsel independently obtaining the content of her text messages. On February 27th, 2015, respondent's attorney filed her verified response in which she said, "With respect to the text message at issue, while respondent knows that none of the text messages were sent between her and Judge Lunsford involved any pending criminal matter, she acknowledges that, with hindsight, she wishes she had not communicated with Judge Lunsford in that manner at all. Respondent did not make any false statements. She did not engage in any fraud or misrepresentation. Respondent never intended to influence the judiciary or influence the court improperly. Nevertheless, as the text messaging was not improper ex parte communication with the court and was not used to influence the court, did not violate the rules of professional conduct. As for the text messaging, respondent did not use that communication in any way with respect to pending criminal matters. Respondent, in connection with this disciplinary matter, knowingly and or recklessly made a false statement of material fact. Respondent failed to comply with petitioner's request for the text messages, and her verified answer states, "We do not have access to any of the text messages at issue." Respondent's statement is directly contradicted by the fact that respondent should have, and in fact did have, access to the county-owned work phone, work computer, and work iPad, as well as her personal phone. Respondent, in connection with this matter, failed to respond to a lawful demand for information. By supplemental request, petitioner revised its concerns regarding the text messages. On August 1st, respondent's attorney filed another response. Respondent has no independent recollection of sending 2 text messages to Judge Lunsford for that matter. On the contrary, respondent does remember a group text in which she later learned Judge Lunsford may have been included, but she has no recollection that she was the intended recipient for the referenced text. Respondent, in connection with this disciplinary matter, knowingly and or recklessly made a false statement of material fact. Respondent's knowledge of Judge Lunsford being included in the text messages is evidenced by the use of he referring to ADA Boob's statements during the hearing, rather than directing the statement to the ADA, which would have been stated as you. The McClure matter. On October 30th, 2014, a hearing was held for recusal filed by an attorney on behalf of his client. At issue was whether evidence existed which would warrant Judge Lunsford's recusal from the matter. The motion stated that Judge Lunsford is a personal friend of respondent, lead counsel in the above-captioned case outside the bounds of a professional courthouse relationship. That personal friendship includes text messaging, telephone calls, social media contact, and social interactions outside of the courthouse. During the hearing, respondent stated, "In terms of the rest of the allegations, I am not dignifying them. He has to bring forth proof before this court goes any further, and I, notably, expected him not to because there is none." By making a false or misleading statement Respondent engaged in professional misconduct by engaging in conduct involving dishonesty, deceit, and misrepresentation. Judge Lunsford also made the statement, "There are no text messages between me and these two. I swear to God, there are no emails. Well, you are going to find emails because we are always attached to emails, but you are not going to find any email that is inappropriate that relates to this trial or any trial whatsoever. They're not there." Respondent failed to correct Judge Lunsford's false statement. Respondent thereafter also stated that the false appearance of impropriety is manufactured by ease, an innuendo, a rumor put in motion. It's a charade, trying to discredit the investigation or hearing. Respondent engaged in professional misconduct by engaging in conduct involving dishonesty, deceit, and misrepresentation. Believe it or not, lawyers are not allowed to engage in conduct that involves dishonesty, deceit, or misrepresentation. So when you hear about lawyers that are lying, they're actually breaking not only the law, but their rules of professional conduct. Respondent made these statements in open court only 5 months after the ex parte communications in Horan and Best. Respondent knew that Judge Lunsford's claim with respect to the text messages was false, as she and he regularly sent each other text messages. In addition to the specific examples discussed, Respondent sent Judge Lunsford 9 text messages during the month of October 2014 and 89 between May 2014 and October 2014. In the course of representing the Commonwealth in McClure, Respondent knowingly and recklessly made a false statement of material fact in open court. Respondent knowingly assisted Judge Lunsford in conduct that is a violation of the applicable rules of judicial conduct. Petitioner advised Respondent, and Respondent's answer said, "It is admitted that Respondent did not correct Judge Lunsford. It is denied that she had any reason to believe she needed to correct him." Respondent, in connection with this disciplinary matter, knowingly and recklessly made a false statement. Again, confronted about her false statement, she said, "Respondent did not correct Judge Lunsford because at the time she had no reason to believe that what Judge Lunsford stated was incorrect. Respondent had no recollection of the Horan email or the fact that her last email in the Cluck matter excluded counsel of record. Respondent, in connection with this disciplinary matter, knowingly or recklessly made a false statement of material fact." Again, when confronted, she said, "The only issue before the court during the McClure hearing was whether there had been text messaging between ADA Boob and Judge Lunsford. Respondent had no recollection of any text messaging in the Best matter, and such texts were not ex parte communications. By way of further response, all such statements remain true. Respondent, in connection with this disciplinary matter, knowingly or recklessly made a false statement." The Hoy matter. November 21st, 2014, a hearing was held on a motion to recuse. At issue was whether evidence existed which should warrant Judge Lunsford's recusal. The motion stated that 62 text messages have been exchanged between Judge Lunsford and Respondent. During the hearing, Respondent stated that Attorney Klenna has no indication and he has no evidence or proof to suggest that any communications between my office and your office are ex parte. Never has this court had ex parte conversations about any cases. Respondent engaged in professional misconduct by engaging in conduct involving dishonesty, deceit, misrepresentation. This was only 6 months after the ex parte communications in Horan and Best. In the course of representing the Commonwealth in Hoy, Respondent knowingly and recklessly made a false statement of material fact in open court. When confronted, she said, "To Respondent's understanding, none of the text messages were improper ex parte communications in court." Respondent knowingly or recklessly made a false statement of material fact. When confronted, she said, "When Respondent made the statement during the argument in the Hoy matter, she had no recollection of the Horan email or the fact that her last email with the Cluck matter had excluded counsel of record. Respondent never intended to make a false statement or to mislead anyone." Respondent made a false statement in connection with that statement. By her conduct set forth in the preceding paragraphs, this is like what I'm going to call part 1 here, because you're going to want to stay for part 2. We're not even done yet. By her conduct set forth in paragraphs above, Respondent violated the Pennsylvania Rules of Professional Conduct. Rule 3.5a states, "A lawyer shall not seek to influence a judge by means prohibited by law." Rule 3.5b states, "A lawyer shall not communicate ex parte with a judge during the proceeding unless authorized to do so by law or court." Rule 4.1a states, "In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person." Rule 8.1a, "A lawyer in connection with a disciplinary matter shall not knowingly make a false statement of material fact at all." Rule 8.1b, a lawyer in connection with a disciplinary matter shall not knowingly fail to respond to a lawful demand for information from the disciplinary authority. Rule 8.4c, it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Rule 8.4d, it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. And Rule 8.4f, it is professional misconduct for a lawyer to knowingly assist a judge or judicial officer in conduct that is a violation of the applicable rules of judicial conduct or other law. So that's bad enough. You are not allowed to talk to judges ex parte. If she had a personal relationship with a judge, that's not okay either, but it is physically possible to have a relationship with the judge and still conduct yourself in accordance with the rules of professional conduct. No, I don't know exactly how, but you would need to not be communicating like this, like text messages during trial, about trial. Yeah, if you had a relationship with a judge and it somehow wasn't misconduct, it would be, anything with work would be arm's length. You would have a personal relationship, and your work relationship would have to be like completely separate. Like you don't have your computer files in the same thing. You don't talk about the cases. You don't nothing. So when motions for recusal are then made because the judge and the prosecutor are seen as in bed together, like, I don't know, it almost sounds like they had a personal relationship, and so that means kind of literally, but this is all allegedly right now. This is only the disciplinary counsel's side of things. When that happens, it does give that it smacks of impropriety, and so if a motion of recusal comes forward, the prosecutor, Stacey Parks Miller, really should recuse herself, or the judge should recuse themselves if whatever is appropriate for that particular matter. That she didn't do any of that, and she continued to talk to judges, and she talked to judges about trials, and she apparently influenced Judge Lunsford. And maybe one of our people, like Tactical, would be able to look up what happened to Judge Lunsford, because I'm pretty sure he is also being charged. But here we have Charge 2, the Brittany Bella matter. Notice that Brittany Bella is in quotes, because Brittany is not real. On or about May 16th, 2011, respondent created a fictitious Facebook account under the name of Brittany Bella. In creating the fictitious account, respondent utilized photos from around the internet of attractive, buxom, scantily clad young girls in order to enhance the page's allure. The account also included that Brittany Bella was a Pennsylvania State University dropout who had moved to the State College area from Pittsburgh in order to portray a connection to the local community. Respondents, Stacey Parks Miller, intention was to utilize the account to friend defendants and or witnesses to obtain information from their personal Facebook accounts, which would otherwise have been private. On May 17, 2011, respondents sent an email to the ADAs in her office as well as to the office secretarial staff stating that she had made a Facebook page that is fake for us to befriend people and snoop. Her name is Brittany Bella. Use it freely to masquerade around Facebook. Please edit it to keep it looking legit. Use it to befriend defendants or witnesses if you want to snoop. When asked about this, she responded, respondent has not located the described email about the Facebook account and does not believe that she would have used that language in the nature described. In order to support the legitimacy of the Brittany Bella Facebook account, in respondent's verified answer she states, the Brittany Bella Facebook account constituted a proper law enforcement operation which lacked active ongoing interaction with the targets of the investigation, and that Brittany Bella's Facebook account's exclusive purpose was to facilitate the self-identification of sellers of illegally and highly dangerous synthetic drugs and paraphernalia. Respondent's verified answer stated that 3 stores were raided, the owners were later prosecuted, and 2 stores were put out of business as a result. Based on respondent's statements, the stores that Brittany Bella's Facebook account would have been tracking and targeting were raided in or about February of 2012. However, the account remained active and was utilized after February 2012 to search for and connect to individuals who had no connection to drug-related activity. Respondent, in connection with this disciplinary matter, knowingly or recklessly made a false statement of material fact. By employing the Brittany Bella Facebook account, respondent personally engaged in conduct that was dishonest and deceitful. By sending the aforementioned email, respondent induced her staff to make misrepresentations and act dishonestly or deceitfully. By providing access to the Brittany Bella account for her staff, respondent assisted her staff to make the representations and act dishonestly or deceitfully. Through the use of the Brittany Bella Facebook account, respondent violated the rules of professional conduct through the misrepresentations and or dishonest or deceitful acts of her staff. While having direct supervisory authority over her non-lawyer administrative staff, respondent failed to make reasonable efforts to ensure that her conduct was compatible with her professional obligations. Respondent failed to make reasonable efforts to ensure that their conduct was compatible with her professional obligations. To the contrary, respondent ordered and with the knowledge of the specific conduct endorsed the use of the Brittany Bella Facebook account by her non-lawyer administrative staff. While exercising managerial authority over her non-lawyer administrative staff and knowing of the conduct at the time when its consequences could be avoided or mitigated, respondent failed to take reasonable remedial action. By employing the Brittany Bella Facebook account, respondent engaged in conduct which undermines the integrity of the criminal justice system. The Hill Matter. May 29, 2012, a criminal matter was initiated against Samuel Hill in Centre County. Mr. Hill's matter was not drug-related. He was arrested relating to an incident in 2012, charged with simple assault, represented by an attorney, and became a friend of the Brittany Bella Facebook account on August 29, 2012. He then pled guilty and was sentenced November 15th. In dealing on behalf of the Commonwealth, utilizing the false Brittany Bella Facebook account with an individual being prosecuted, respondent or an attorney acting on her behalf implied disinterest in Mr. Hill's matter. Respondent reasonably should have known that by connecting to Mr. Hill through the use of the Brittany Bella Facebook account, Mr. Hill misunderstood her role in the matter and respondent failed to make reasonable efforts to correct the misunderstanding. On or about September 11th, 2012, a criminal matter was initiated against Jolene McClure. Contrary to respondent's position, as stated above, Ms. McClure's matter was not drug-related, and Ms. McClure's charges were initiated approximately 8 months after the exclusive purpose of the Brittany Bella Facebook account would have concluded. Ms. McClure was arrested relating to an incident in 2010, charged with various offenses related to the injury of an infant under her care. Respondent's verified answer alleges that, to the best of respondent's knowledge and understanding, and based upon a review of the friend request section of the Facebook profile in question, individuals became friends of the Brittany Bella account profile on his or her initiative, not due to any invitation sent by anyone on behalf of the Brittany Bella profile. On November 9th, 2012, the same date Ms. McClure's criminal case was transferred to the Court of Common Pleas, the Facebook account was utilized to search for Ms. McClure and all 3 of her sons. At an unknown date, presumptively the same date of the search, friend requests were sent from Brittany Bella Facebook account to, at minimum, Ms. McClure and Cody, one of her sons. Friend requests were sent from Brittany Bella, evidenced by the petitioner's review of the Brittany Bella's Facebook page sent friend requests list, contrary to respondent's position. Respondent, in connection with this disciplinary matter, knowingly or recklessly made a false statement. Ms. McClure and Cody did not accept the friend request. In dealing on behalf of the Commonwealth with witnesses, individuals under investigation, and individuals being prosecuted through the use of the false Brittany Bella Facebook account, respondent and her attorney acting on her behalf implied disinterest in the matters. Respondent reasonably should have known that the unrepresented persons respondent was connecting to through the Brittany Bella Facebook account misunderstood her role in the matter, and respondent failed to make reasonable efforts to correct the misunderstanding. Besides Hill and McClure, petitioner has been able to identify 27 individuals who are friends of the Brittany Bella Facebook account and who have criminal records which are not drug-related. Besides those individuals above, petitioner has been able to identify an additional 8 individuals who are friends of the Brittany Bella Facebook account who have criminal records which are drug-related. Notwithstanding the number of individuals with criminal records who are friends of the Brittany Bella Facebook account, petitioner has been able to identify an additional 4 individuals who are friends of the account who are relatives of those individuals with criminal records. Petitioner has been able to identify 2 individuals who were sent friend requests by the Brittany Bella Facebook account while active criminal cases were open against them. By her conduct, respondent has violated the following rules of professional conduct. 4.3a. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. And this is not disinterested as in like, hey, I don't want to go out with you. This is like that they're not an an interested or conflicted party, that they don't have a conflict of interest. In this case, the Brittany Bella Facebook account is the DA, so by not telling people that the DA is friending you on Facebook, she is implying that she, Brittany Bella, is not an interested party, does not have a conflict of interest, is not involved in the matter, basically. So instead, what this rule is saying is that you can't imply that you're not an interested party. That's what disinterested means. 4.3c, when the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer should make reasonable efforts to correct the misunderstanding. 5.3b says a lawyer having direct supervisory authority over a non-lawyer shall make reasonable efforts to ensure that person's conduct is compatible with the professional obligations of the lawyer, meaning that people who work for a lawyer are under the same ethical duties as the lawyer, and it's the lawyer's job to make sure that happens. 5.3c1, a lawyer shall be responsible for conduct of such a person that would be a violation of rules of professional conduct if engaged in by a lawyer, if the lawyer orders or, with knowledge of the conduct, ratifies the conduct involved. Rule 5.3c2 says a lawyer shall be responsible for conduct of such a person that would be a violation of the rules if engaged in by the lawyer, if the lawyer has comparable managerial authority over the person, and in either case knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. 8.1a says a lawyer in connection with a disciplinary matter shall not knowingly make a false statement of material fact. Rule 8.4a says it is professional misconduct to knowingly assist or induce another to do so to violate the rules of professional conduct or to do so through the acts of another. Rule 8.4c says it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And Rule 8.4d says it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Wherefore, petitioner prays that your honorable board appoint a hearing committee to hear testimony and receive evidence in support of the foregoing charges, and upon completion of said hearing to make findings of fact, conclusions of law, and recommendations for disciplinary action as it may deem appropriate. Respectfully submitted, Paul Killian, Office of Disciplinary Counsel. So on last Monday, we had a story about eat crow while the crow is young and tender, or surely you will eat the crow when it is old and tough. This is a maybe a less clear example, but a better example of first off, I mean, some of this misconduct is serious misconduct if these things are true. The other half of that is she could have corrected some of these things and not be guilty or liable or facing this kind of misconduct charge, because there's no reason to perpetuate these things. Like, if she got caught doing those things, why lie about it then? That's not necessary. Well, she does have a statement from Center County District Attorney Stacey Parks Miller. The allegations reported today about Center County District Attorney Stacey Parks Miller are completely and patently false. Ms. Miller has been the chief law enforcement officer and lead prosecutor for Center County since 2010. Ms. Miller is a person of integrity, and her dedicated commitment to fighting crime and protecting citizens of Center County cannot be and should not be questioned. Any suggestion that Ms. Miller forged a judge's signature on a court order is not only absurd, but it is also highly defamatory and extremely questionable. I don't remember that allegation being in there, but we know about it now. It is no wonder that the person who made such an unsubstantiated and egregious accusation is herself under investigation for making false reports. Notwithstanding the absurdity of these allegations, Ms. Miller takes such claims, even false claims, extremely seriously. Therefore, when these false allegations first surfaced, Ms. Miller brought them to the attention of law enforcement in another jurisdiction for an objective and independent review. The investigation into these allegations and the person making them is now being conducted by the Pennsylvania Office of the Attorney General at Ms. Miller's request. Ms. Miller continues to cooperate fully with the Attorney General's ongoing investigation for the same reason that she voluntarily disclosed the false allegations in the first place. Ms. Miller remains confident that the matter will be thoroughly and properly investigated, and any purported accusations of wrongdoing against her will be quickly and completely dismissed. Rest assured that the persons responsible for making these false allegations will ultimately be prosecuted to the full extent that the law provides. Which is slightly confusing to me, because that only addressed one person's false allegation that she forged a judge's signature. Didn't address any of the allegations from this petition from the Office of Disciplinary Counsel. Maybe that statement was made before the petition was filed. The petition was filed on the 22nd of February, and there's no date on this other statement. It also is not signed, so you'll just have to trust me that I thought I got it from a reputable source. So, what do you think of that? That's pretty terrible. I honestly don't even know what to say about that. People who, again, not assuming that this is true beyond, speculative purposes. So just assuming that this is true. Assuming that the Office of Disciplinary Counsel did not bring these charges after an investigation lightly. I'm going to guess that there's some kind of truth to this, and that the results will probably be some kind of disbarment of Ms. Parks Miller, because this is not just illegal ex parte communication. It's influencing a judge. It's not correcting herself when confronted about it. It's not admitting it. It's perpetuating the lie. This is where the crow is no longer young and tender, and now you'll be eating a punishment that is much worse because you didn't eat the crow when it was young and tender. As you saw from the previous case a week ago, that was pretty egregious conduct over the course of a year, lying to a client about a $55,000 or $50,000 settlement. It was pretty egregious, and that person was not disbarred because they fessed up to it and took remedial action. It wasn't enough to prevent a 1 year and 1 day suspension and a reprimand and disciplinary action and all that, but it was enough to set up a situation where that person, that attorney, can now move on. Now, whether they'll be able to is another story, but that's not the subject here. Ms. Miller, if this is true, and if even a small part of this is found to be, if she is found liable or guilty, it will have worse consequences, in my humble opinion. So, yeah, that's a real interesting one. If true, what happens with all the cases that are included in the petition? Very good question. Those defendants will have reason to go back to court and ask for either a new trial or to have the charges thrown out or their record cleaned up or something. I am not a criminal defense attorney. I don't know what's involved in that, but I imagine those people should be, or probably already have, talked to their defense counsel about this alleged misconduct and what it would mean for their case. But yes, if it can be shown that so there's a couple ways I could see this playing out. If it can be shown that she influenced the judge, then yeah, definitely the trial gets thrown out or whatever, and they have to hold a new trial. And then the district attorney might not hold a new trial if the person has already been incarcerated for some time and it's just not worth it to try and get him back into jail for a few more months or something. So that could be something. Also, it could be just that a later on a court, or maybe even something like the attorney general or something, petitions a court and asks for some things to be vacated completely because they were mishandled. But yes, generally when the attorney general, when the district attorney mishandles things, yes, the things that were mishandled are generally up for review, if not worse. So what does everybody think of that? Definitely let me know what you think in the comments of the YouTube video below and in the chat on the Twitch live stream. I am really hoping that Ms. Parks Miller is not going to be the district attorney for Center County very much longer, if she still is. Tactical, were you able to find anything out about Judge Lunsford?
Yes. So in 2014, he was reassigned so that he was not allowed to hear any more criminal cases with the exception of DUIs. And then in 2015, he was running for re-election. And then shortly after he began running, he announced his retirement. Some of the news articles that I've been reading did mention things like the McClure matter, and it looks like he might have gotten caught, or people might have been aware of the improper behavior.
Not knowing any additional details than what you've just mentioned, I can sort of talk about this, I think. The Office of Disciplinary Counsel doesn't really have the ability, as far as I know, to like throw you in jail or fine you an amount of money. I don't know for sure. Someone could correct me. They mostly deal with your law license and do you have the right to practice law. And so they'll disbar her or suspend her or him. In Judge Lunsford's case, it sounds like he retired by relinquishing his law license, which is the same thing as them. I mean, it's not the same way, but it's the same effect as them suspending or disbarring him. He doesn't have the right to practice law. So if he voluntarily gives up his license permanently, then the Office of Disciplinary Counsel doesn't really have anything else they can do aside from prove their allegations to be true. And so a lot of times the Office of Disciplinary Counsel will agree to drop their disciplinary action in return for you giving up your law license. And that's something that actually happens to psychologists and doctors too. So it's a thing. A lot of times the boards will let you give up the license without holding the full hearing. Sometimes they'll want you to stipulate to something, but without having to go through the whole full hearing, they'll let you get out of the case as long as you experience the same or similar consequences. Can a lawyer be sued for putting lawyers in general in a bad light? No, not really. What we're supposed to do is police ourselves, and if we see a lawyer casting other lawyers in a bad light, like, for example, if my YouTube channel started saying really nasty things about lawyers that were untrue, I would expect to receive a complaint from lawyers, from other lawyers, like a formal complaint to my bar, to ask them to look into what I'm doing and if it's improper. That's about the most that I think can happen. It would have to be much more direct for it to be connected enough for someone to actually sue. You would need legal and factual cause, meaning you would have both proximate cause, which is a legal question about how many steps away are we allowed to still find someone liable for something, and also but-for cause or factual cause, meaning that, like, except for this person's conduct, the bad things that I'm complaining of wouldn't have happened. So if I can't show damage that is both connected directly by a but-for cause, and I also can't meet the legal standard for proximate cause, then I probably don't have even the beginning of a case to file. So, no. I'm assuming all these rules are the basics taught in law school. Do people really think they can get away with these things? That's a really good question, Spitting Llama. I really like that question. You reminded me to talk about this. The rules of professional conduct are an entirely separate course in law school. Like, you go through an entire 14-week course in law school for rules of professional conduct. And then you take a separate exam before the bar exam. If I understand correctly, you can't even take the bar exam until you have passed your professional conduct exam and your professional responsibility examination. So a lot of law schools will have their attorneys, or at least in Pennsylvania, my law school had this attorney take the professional responsibility course early on in law school so that we were prepared to then take the professional responsibility exam directly thereafter before finishing law school, because there's no time limit on that. And then when we go to take the bar exam, we already have it done and don't have to go and take it again or try to cram a third test into the same time period. So you take the professional responsibility exam early, and then you don't have to worry about it. So yes, every attorney has to pass a test, a very hard test, well, a slightly hard test, on their rules of professional responsibility, that they know them, they understand them, and they know how they're applied. Like, they'll give you scenarios and stuff too, and you have to be able to say what's right and what's wrong, how to handle your money, how to handle your client's money, how to not tell lies. I mean, some of this stuff really isn't that hard, but then the rules do set down some of the stuff that's super complicated, like conflicts of interest and advertising rules and things like that. So every attorney is supposed to know these at all time. I mean, I'm not like, it's not like a drill sergeant is supposed to walk up to me and, Mr. French, state your second rule of professional misconduct or professional conduct. But rather, we're supposed to remember, what the substance is. When you have a client, you can't talk to, when you have an opposing party, you can't talk to the opposing party's client, that kind of thing. Stuff like that. Like if you have an opposing counsel, you can't talk to opposing counsel's client, stuff like that. So we know all about our rules of professional conduct, and Stacey Parks Miller really shouldn't have any excuse if these things are true. She shouldn't have any excuse for not knowing what she was doing was wrong. She probably, and this is my opinion, probably thought no one would ever figure it out or care or notice, or maybe she just really thought that she was special and was going to get away with it. I don't know. If she truly was so ignorant as to think that what she was doing was not a violation of her rules of professional conduct, that's a level of ignorance I have no understanding for. If she passed the bar and she passed the professional responsibility exam, there's no excuse. I don't even think that's a possibility that she could have known, or that she could have genuinely thought that she was doing nothing wrong. I don't believe it. But that's just my opinion, and I'm sticking to it. Do you think situations like this do happen and go unpunished? That's my question too. This one was pretty obvious. People apparently were aware of it even before the disciplinary council got involved. There were 2 motions for recusal claiming that text messages were known about already. So it sounds like she didn't have a really great criminal mind about her. She didn't really understand how she has to hide things like that better if she wants to get away with them. I'm glad that she didn't hide them better, because not only are we doing a story about it, but criminal activity was caught. So maybe it's criminals are stupid is one of the helpful things, or maybe criminals that get caught are stupid, and maybe criminals that don't get caught aren't so stupid. I don't know, but one of my concerns is that there's probably stuff like this that goes on that people know better how to hide it, and therefore doesn't get caught and reported and prosecuted. So yes, that can happen. What I will say in defense of my industry is that this is exceedingly rare, as far as all indications I can see and know and understand. I have never had judges that seemed to act inappropriately. I've had judges that I disagreed with, but I've never had a judge act inappropriately. She didn't correct it. She didn't try to make any remedies. She didn't try to fix anything. She didn't eat crow while the crow was young and tender, and she will suffer this disciplinary action and its consequences. And that, my friends, is our show for today. I am going to go back to bed and try to get some rest from my 36-hour drive. Did I just add 6 hours to it? It's been 36 hours is what it is. It was a 30-hour drive, and it was 36 hours ago. So I'm tired. And I don't know if you noticed me stumbling over my words a little bit extra this time. It's because I got about 4 hours of sleep on that 30 hours of not sleep, and I'm still pretty tired. So thank you for the birthday wishes. Thank you for the sleep well wishes. I will get the dogs, and I will be back in a moment. Yes, we have a ton of new patrons this month. I have them scrolling on the LED panel already, but I would definitely like to thank our $500 video sponsor, Kareem Harper. Thank you very much. I'll be in touch with what Kareem would like us to produce very shortly here. Don't want to say too much until I've spoken to him. Thank you very much to our $50 plus supporters, DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Eevi, Andy, Kyle Mudrak, John H. Andersen, Verement, Tayne, Sean McNamara, William Gonzalez, Michael Pearce, and LVE. Thank you all very much for your support, and the $5 plus supporters are scrolling on the LED panel behind me and on the will be on the screen, on the video, when it's produced. The dog is pushing me out of the way. Hello, the dog. Hello, the dog. How are you? How are you? There are 210 $5 plus supporters. Rah. Rah. Thank you all very much for your support. Let me yank this over this way and grab a dog treat for a dog. Hup. Good boy. Thank you very much to Kaylee for some healthy, waggy Easter peanut butter flavored cocoa and gluten-free dog compatible Easter eggs. They're like chocolate flavored, but there's no actual chocolate or bad stuff in it. It's all dog compatible stuff. It's a made for doggy Easter egg. So we really appreciate that. That was super cool. Thank you very much, Killing. And that's our show. Thank you everyone for joining me. Of course, I am Leonard French, your favorite copyright attorney. And I'm going to go get some rest, and we'll see you in the next video. Through the use of the Brittany Bella Facebook account, respondent violated the rules, and 8.4D says it is professional misconduct for a lawyer to engage in conduct that is presidential. I need that nap. Wow.